Today we have with us Rebecca Salmon, and Miss Salmon is originally from upstate New York. She actually lived in Germany for 5 years before immigrating to Georgia. She completed her BA in Psychology and Conflict Resolution at Brunel, and she graduated cum laude in just 2 years. She went on to earn her JD from the UGA School of Law. Ms. Salmon has worked for Catholic Charities since April of 2006, helping to provide legal services to the indigent immigrant community. Through her EJW fellowship, that stands for Equal Justice Works, Ms. Salmon worked to develop the Immigrant Child Advocacy Project of Catholic Charities Atlanta. Her project addresses the needs of unaccompanied immigrant children facing severe immigration challenges and other instances of abuse. Since 2010, Ms. Salmon has been the managing attorney at a Salmon Law Firm, LLC. She is a 2010 DeKalb County Liberty Bell Award recipient and a national speaker on children and immigration rights. Please join me in welcoming Ms. Salmon today to our presentation.
Thank you. I'd like to thank the Barton Clinic and all of you for attending. She already did the introduction. I recognize a few faces. I've seen a few of you. Can I have a show of hands? How many here are attorneys? How many here are social workers? What's everybody else? Pardon? CASAs. Okay, good. Well, that's a good collection. The Immigrant Children's Advocacy Project was started to help children who are in care, in defects care originally, but we also, in publicizing our services, start picking up a lot of people in the community. It's kind of like the amount of immigrants we have in the United States. There's those you measure, and then there's that much more that you don't even know about yet. I used to give this presentation and only talk about special immigrant juvenile status, which is a remedy specific to abused and abandoned children. But because we do so much work with defects, we expanded it, and we now talk about other remedies that are available for the whole family. It's not our wish that you get citizenship and you give away your right to be with your family. That's never a good option. We don't work to keep kids in this country who shouldn't or can't stay here. A lot of times the best answer for a child who's been abused or abandoned or even neglected is reunification with that family, whether it's here in the United States or in their homeland. But if you're treating the whole family and you'd like to reunite the child, there are some remedies that can help the whole family for the immigration as well. Let's talk first about T-immigrants, U visa status, Violence Against Women Act, and then we'll eventually talk about special immigrant juvenile status. Congress as a whole recognized that immigrants are particularly vulnerable to abuse and to crimes, domestic violence, trafficking, and there's a lot of reasons for that. You come to this country, you don't speak the language, you're not familiar with the area, you don't have a strong community base or family base to assist you, you're marginalized, and then add on top of that the fact that you're undocumented. So you're afraid of everyone you talk to. You're afraid of the police, you're afraid of the landlord. A lot of times they become victims of manipulation and crime. The T visa was for trafficking. And who knows the difference? Give me some ideas. What do you know about people who've been trafficked? What immediately comes to mind? Children. What other? Who here gets their nails done? How many times do you go to get your nails done and you don't see the same person the next time you're there? It's like a new batch every time you go. And Atlanta is the #1 hub for trafficking in the whole United States. More people are trafficked through Atlanta than any other place in the United States. And there's a lot of investigation. There's a push from DHS this year, Department of Homeland Security, to publicize what happens with human trafficking and how to recognize it. A lot of people say, well, but didn't they pay to come here? Well, there's a difference between smuggling and trafficking. If someone starts out as being smuggled and somehow en route ends up being trafficked, they're still going to be eligible for this relief. Someone who is smuggled may want to come to the United States. They may want to come here. They may even pay a coyote or someone who will help them enter the United States unlawfully with the promise that maybe they can work here. But somewhere along the line, the consent changes, and the result is that they end up here in the United States and they're not free. They can't go and do what they came here to do. They're either indentured servants, they're sold into sex slavery, they're sold into to sweatshops. There's all sorts of stuff. We recently had 3 young girls from China who were abandoned in China. Their births were never registered because they were girls. They were left on the doorstep of a gentleman who had raised them. And then his wife died, and he didn't have enough money or wherewithal to take care of the girls. And someone had come to his house one day and said, I can get these girls jobs working in a t-shirt shop, and they'll make more money than they ever could in China. So I'll help them. I'll get them passports, and I'll get them to the United States, and their life would be great. So this guy thought, well, this is good for them because I can't take care of them, and I'm getting old. So he helps them onto the plane. The girls didn't fly to the United States. They flew to Mexico. And for 3 months, they were moved around Mexico from house to house every 2 to 3 days. And eventually, 2 of the girls escaped. One was caught at the border and put into ORR. We'll talk about that. It's like a federal foster care. One girl made her way to a number, to a phone where she called a gentleman who her adoptive father had told her, if you ever get to the United States and you need help, call this man. And the third girl, unfortunately, was sold into the sex trade in New York and has spent the last 4 months in New York until one night the man who she was sold to didn't come home and she was able to escape. Luckily, all 3 girls are now in Georgia, back here in Atlanta together. 2 of them are sisters, one of them is just a known friend. But all 3 girls, even though they qualify for this T visa, they're all also SIJS candidates. And we'll talk about what the differences of why you would pick one remedy over another. They willingly wanted to come to the United States to work. They thought that it was going to be lawful, but it didn't matter whether they thought it was going to be lawful or not. Somewhere along the line, that whole story changed, though, and it moved into the coercion that causes smuggling. To qualify for a T visa, the person has to be a victim of a severe form of trafficking in persons. We've met with the trafficking section of DHS here in Atlanta, and my first question is always to them, what's less severe trafficking? You know, define that for me. I don't know. If you've been trafficked to me for any reason, it's severe. They have to physically be present in the United States. We were worried that one of the girls may have been lost when they had escaped through Mexico and was somewhere in Mexico, and there's nothing that you can do to qualify if you're not within the United States. You have to then comply with reasonable requests for assistance, which is why the girls were meeting with the trafficking section here in Atlanta to give them as much information as they could about the man who came to her adoptive father's house, about the men who were on the plane, about the people who gave them their passports. There was a lot of control on the plane. As soon as they were seated on the plane, all their documents were taken back. And as soon as they got off the plane in Mexico, they were herded into separate trucks and stuff. So all that information was gathered. If the child is under 18, they don't even have to do that. But these girls were willing, and they had very good memories of what they had gone through, which is amazing. They didn't speak English or Spanish. They spoke Chinese, and the people who were moving them only spoke Spanish. So it was very interesting, the information, the details they had when you take language out of it. They have to have suffered extreme hardship involving unusual and severe harm, or they have to show that they would suffer unusual harm if they were removed from the United States. If you qualify for a T visa, the first form that you get is certification. It's good for a year, and what it means is you can tap into state and federal benefits. I know a lot of you know about SB 529 and all the other restrictions against immigrants getting help on a state or a federal level. So this form authorizes them to have benefits.
Okay, can I?
Yes, ma'am.
With regard to the last statement, suffer extreme hardship involving unusual and severe about removal from the United States. Does that mean that the individual has to show that if they were sent back to their homeland,
that they would be in danger? And a lot of that is easier than you would think to prove for this very reason. These girls started in their home. They were recruited from someone who offered to traffic them. And whether it was that way or through use of a coyote, typically when you pay someone to smuggle you in, you would give them half before you leave and half once you get here and make money. They know where you're from. This is organized crime. They know who your family is. They know where they're located, and they're coming to look for their money. If you got deported and it didn't work for you, it doesn't matter. You're still paying.
So the harm could be not just to yourself, but to your family members?
Well, the harm has to be to the person if they were returned to their homeland. That person who trafficked them may likely come look for them again.
I just want to ask, if I want to be clear, so you're talking about, this is trafficking, but what form is it that you're talking about? What form?
That's the interesting thing.
Okay.
It's a self-petition. You can't have the form. I can't have the form. Nobody can have the form. We don't know where the form is. We don't know what the form's called. You have to start with the Trafficking Victims Office, and luckily we have one here in Atlanta, or you can start with the FBI and get a certification from them. But we don't fill it out. They do it for us. Unfortunately, even though we had a lot of information from these girls, none of that information was enough that they wanted to pursue through the local office here. I limited resources. They want to get the big cases. They didn't think these were big enough. So these girls, they could have got the certification for the benefits right away, but they probably weren't going to apply for a T visa. They weren't going to go through and do that here in the local office. And because we had the SIJS as an alternative, why spin your wheels on that when we could do it this way? So we don't know what the form is. We don't know what it's called. Can't have it. I can't get it. But I can tell you where to go if you think you have one of these cases. And the interesting thing about immigration is there's not a lot of remedy out there. But when there's a situation, there's a lot of different ways we can look at it. And we can find the best remedy. And I always turn to SIJS if we can, because it's the only remedy that's guaranteed to be complete within 6 months. There's no completion times in any other form. Okay? The good thing about a T visa, though, is that you can apply for family members. One other girl that had been trafficked had a baby back in her homeland, so that's something we were concerned about. What were we going to do with that baby back there? How are we going to reunite the baby with the child? So that was something that made more sense for her. There's 5,000 visas each year available, and there's no limit for how many family members can come. I know more people are going to say, a limit? There's a limit to victims. There's a limit to crime. Doesn't make sense to us either. We haven't reached the limit ever, but for U visas there was a limit, and we reached it last year. And they keep accepting applications, and the next year when the visas come out, they start to use them in that order. So I think that they'll eventually address that limitation to be more in line with what the relief was designed to do. Did you have a question?
Yes, I'm just trying to get a better understanding. The initial children you spoke about, thank you, they were promised to come to the U.S., but it sounds like a Mexican transported them to Mexico. So I'm trying to figure out.
They got on a plane in China, and the plane went to Ciudad Juarez in Mexico.
So I'm trying to figure out how they qualified for
In
U.S.
Mexico, they were trafficked around Mexico and brought into the United States. Now they're physically here in the United States. Their goal was, the traffickers'
So they
goal
came from
was
Mexico
to get them into
to
the
get them
sex
here.
trade
Okay.
in the United States.
Okay, I missed that part. Okay,
Okay.
thank you.
Okay. Thank you. The good thing about a T visa is that you're eligible to work in the U.S. You get a work permit. You get permission. You get a Social Security number. You file your taxes. It's good for 4 years. There can be extensions if there's needed as far as testimony. But after 4 years, you can also apply on your own to become a permanent resident. This is a temporary visa. You're neither permanent nor visiting, but it's temporary. If you can then apply for permanent residency, that's a path to citizenship. And to apply for permanent residency, you have to qualify. You have to be admissible. There's waivers for the fact that you entered unlawfully, but you can't have any crimes. There can't be other health reasons or other bars to your adjusting and becoming permanent resident here in the United States. And that would be the same to apply for the derivatives that you're going to bring from the homeland. U visas. These are like mini Ts. These are more localized crime. This was designed to aid law enforcement investigating crimes, because we all know if immigrants are afraid of being deported, the last thing they want to do is call the cops and say, I've been beaten up, my house has been robbed, I'm being extorted in some way. They're not going to reach out. And a lot of these immigrants come from countries where the police aren't as honorable as we would hope that our police are. So the same thing, this is a U visa application. There's a list of annotated crimes that have to have occurred for you to qualify to apply for this relief. Rape, torture, sexual assault, abusive contact, blackmail, extortion, you can read the list. It also includes someone who had attempt, conspiracy or solicitation, And there's also some similar activities. What it requires, though, is a certification signed by law enforcement or a DFACS worker. And this is another way that we sometimes go the U visa route. If for some reason, perhaps dad was the aggressor, he was sexual incest against a child, and ultimately the child was returned to the mother, father's in jail, deported, what have you, you'll want to keep that child with the mother if it's a fit setting, but mom and child are both undocumented. I know you have concerns with stability. How is mom going to get employed to meet the case plan? This is a route where perhaps the child would be the key person on a U visa and mom would be a derivative. To qualify, you have to be the victim of qualifying criminal activity, that list, or others. You have to have suffered physical and mental abuse. For this type of application, we like to get the child or the family member into counseling right away. Not only is it a good idea, but it also helps us with a report that we'll want to include with the application. The person has to possess information about the criminal activity, and what that means is they have to have been the victim. They didn't see it happen. They were the victim, and they can give police statements. They may be called up to testify, and they have to be helpful in the investigation. That need to be helpful doesn't apply if the person, the victim, is under 18. They don't have to be helpful. It's great if they are. If they aren't, then there's an understanding. And the crime has to be activity that violated a U.S. law. This is the part where it's still unclear in our jurisdiction or others here in the United States. It starts out saying that they have to be in the United States, but if that crime violated a crime in the United States, there's the possibility that you could still apply for a U visa even though that crime occurred outside the United States. That hasn't worked in our jurisdiction, and I don't see where it's going to, given our political climate. But the way the law is written, there's a possibility that it could be interpreted that way.
Can I ask a question?
Yes?
I don't understand, why do you have 1 and 4? I mean, you have to be a victim of a qualifying criminal activity, and then you have to be a victim of a criminal activity that violated U.S. law. Aren't all of the qualifying?
That's the way the law is written, and that's why we argue that if they specifically put number 4 in there, why would you, unless you intended to protect people who were abused in another homeland but now here, and that crime violated a U.S. law. What we see in other jurisdictions with this working is child prostitution. And it occurred in a foreign land, it's against the United States law, and then the child's here. So that's where we've seen that work. This is a self-petitioning application. I don't know what your immigration knowledge is, but typically when you apply as a family petition or a work petition, you have to have a qualifying sponsor who vouches for you. And basically they're saying you're not going to become a public charge for a certain amount of time. They have a requirement that you show that you meet the minimum poverty levels, and you have to do an affidavit of support. That doesn't apply to this relief. The form here is called a 918. So we know the form, we know where to find it. And then the 918 certification is what the police would sign, and it's actually a form. Before these forms became available, we did U visas for a few years without any forms. We just wrote a letter and described what happened and put all the information that we could, police reports, medical reports, counseling reports, bills, as much information as we possibly could about the crime, explaining the eligibility of the person. But now we have forms, and now we have certifications that have to be signed, like I said, by a law enforcement agency or a DFACS agency, someone who's targeted or tasked with investigating a crime. For the example where the child might be a victim of incest, very often we have DFACS workers sign off on that because the child's removed from the home and y'all are the ones doing the investigation. They can also apply for family members, like I said. This is something that if a non-citizen child suffers, they can then include their parents, immediate family members, brothers, sisters, and parents.
Would they be able to do that, or would they have to obtain the visa before they can apply?
They have to apply concurrently. We have another situation where 2 young children's mother was murdered by the father. Aunt is now in care with them. It would have been good if we had waited a little while until Aunt had adopted the child and then applied concurrently. We've tried to go back and say, you know, he was granted a U visa because of this. Now the aunt is the adoptive mother. Can we apply after the fact, and we've been denied. So it has to be done concurrently. Another good reason then would be if a lot of Hispanic community, they don't get married legally, they just live together. That's not recognized under Georgia law, so you're not going to be able to apply that way. So if there's a qualifying crime and perhaps mom now has a new partner but they're not married, get married before you apply for the U visa. Have to be legally married, has to be that connection. There's 10,000 of these each year. There's no limit for family members. Like I said, last year, somewhere around the middle of September, I think we met the cap, and they stopped issuing. But then the 1st of October, when the new numbers come out, they just went back and started where they left off. So we don't know what they're going to do as far as increasing the numbers, but we suspect they probably will, because I don't see where they can put a cap on crime. And the whole point is to get people involved in decreasing crime for everyone by proper reporting. This as well has a 4-year duration. After 3 years, you can apply for permanent residency.
Is there a limit on the number of extensions you can apply for?
There's not a limit that I know of, but I can't imagine a time where you would want only an extension. The longer that you're without status, the more at risk you are. The law could always change. If your goal is to stay here, you want to get status as soon as you possibly can. You have to be a permanent resident for 5 years before you can apply for citizenship.
Okay.
Any crime, any number of things could happen in that meantime before you become a citizen where you could be deportable again. So if your goal is to stay here, I would stress that you'd want an extension. Wouldn't really serve a purpose. It would be better to go ahead and do the adjustment.
Status. Okay.
Did you discuss the eligible to work in the U.S.?
Yes, and that's really important here in Georgia, eligibility to work. Within there's certain applications with immigration where you can also file a 765 or permission to work. There's very few applications in immigration that have strict timelines. The 765, once it's requested, once there's an approved petition hooked to it, the 765 or your work permit has to be issued within 90 days. That's huge, especially in Georgia, because the eligibility to work with a work permit is tied to your ability to get a driver's license, is tied to your ability to get around, is tied to your ability to walk down the street. I mean, it's all tied together here in Georgia. So it's real important. These benefits not only allow you to stay here, to reside, but also to take care of yourself, to get a job, to become productive members of society, not to be marginalized. And that's the whole point, to take victims and put them back into a place of self-sufficiency. The Violence Against Women Act provides immigration relief to victims of domestic violence. Congress recognized, again, that immigrants were victims of domestic violence because of that coercive nature of one person having status and the other person not. To qualify for VAWA, again, is self-petitioning. There's requirements, though. It has to be a spouse, children, or parents of permanent residents or citizens. So if you have an abusive partner, or abusive husband or wife, and you're undocumented, and your abusive partner is undocumented, you're not going to qualify for VAWA relief. That's something we're going to have to probably look at a U visa, because you're then a victim of a crime. VAWA relief is only for someone who's married, legally married to a U.S. citizen or a permanent resident. You don't have to currently be married to them. In 2005 is when it changed to apply equally to men and women. It used to only apply to battered women, but Congress recognized that there's battered men out there as well. You have to be or have been married to a citizen or a resident within the past 5 years. So if you have someone who was in an abusive situation and finally divorced that person, and they're coming up on their 4th year of being divorced, we really need to look at that application and see if it's something that would qualify under VAWA relief before that 5-year period expires. The person could have been a child of a citizen or a resident, the parent of a citizen, or the spouse of a citizen or a resident. You have to prove that the marriage was entered into in good faith. That's a biggie in immigration. Fraud is a biggie. So we don't want that, I met my husband in Jamaica, and we were on vacation, and he offered me $10,000 to come to the United States, but then when he got here, he beat me. It's not going to be a good faith marriage. You have to show that you entered into a good faith marriage, that your intention was to remain married, and through no fault of your own, you were then the victim. Okay? They have to prove that they were subject to battery or extreme cruelty during the marriage. We like to see police reports. We've been successful in getting VAWA relief without police reports. It's a lot easier if someone called the police and we had documented evidence, we had testimony, we had affidavits, we had doctor's reports. The more evidence you have, the better your case is going to be, the quicker it's going to be approved. They have to have actually resided with the abuser. We have some people who got married in a foreign country, were waiting for status. They obtained their green card through consular processing, came into the United States, but never lived with their abusive partner. They then probably won't qualify. They also have to show good moral character. For some reason, the battered spouses that we deal with through Catholic Charities, all of them have shoplifting convictions. We don't know what the connection is. I don't know if it's anecdotal, but no one's done any statistical research. There's a lot of shoplifting, and I guess it kind of goes back to that control feature where they wouldn't have access to money. We can overcome some of that criminal activity. We have to tie it to the abuse, and that's again where the counseling is helpful, not only to the person, but also to overcoming a reason that they may not be able to adjust. The benefits of a VAWA petition. You're placed in deferred action to prevent removal. This is real important. If you're before an immigration judge and you have a VAWA petition approved, the government's going to stop trying to deport you until we sort it all out. That's huge. There's not a lot of ways that you can stop the deportation process with a proposed form of relief. So this is a good one. You can work in the United States, like I said. Once you get that approval, then you get a work permit. The changes to the abuser's immigration status isn't going to hurt your petition. If perhaps your abuser was a permanent resident and now he has a domestic violence charge or a couple against him, that may be the reason to revoke his residency, and he may be in deportation proceedings and be in the process of leaving the United States. That's not going to hurt your right if his residency is removed, or her. Remarriage after approval doesn't affect status. If for some reason we see abusive partners marrying again quickly, that happens, that's not going to hurt your ability to have that relief or your ability to then later on, once you're a resident or a citizen, to petition for somebody else. And they can adjust to permanent resident status after approval. All right, that was a whole lot of information on kind of general family benefits. Any questions on that, or do you have any particular case questions? No names, no specifics, but just general questions about situations that you see in your caseload. Nobody?
I just want to ask you that one more question about, so you have the T visa and the U visa, right? The two
Correct.
different ones. And they have the different eligibilities and the benefits for them. But for that, the U visa is just from the DFACS workers and the police officers that can get you to that position? Or like if they were just out there and they were being abused, could they go to that office?
No,
Do an office or
there's not an
anything?
office for the U
Okay,
visa.
that's-
You really
yeah.
do need to seek an immigration attorney because they have to assess your case. They have to see if it's rising to the level that it's going to qualify. The good thing about U visas is they're processed in Vermont, where the VAWA petitions are. So it's a separate office that's specifically dedicated to victims and vulnerable persons. So that's good. They could see you. They could see anyone at Catholic Charities, any immigration attorney, definitely. And then they will look. You know, if they come in with one police report and what it was is that there was a 911 call to the home and there was an argument, that's not going to be the strongest case. But that doesn't mean that it's not a strong case. Through a consultation and the person explaining this long history of control, whether it might have been emotional or verbal or physical abuse that occurred, we don't always call the police. So maybe that one little report would be enough with all this other evidence. A packet of information for a VAWA petition might be 2 or 3 inches thick. You really want to put everything forward in that application to immigration so that they can assess your particular case and see if you qualify for the intention that Congress had to protect battered spouses. Yes, sir.
How difficult or how much information does the certifying official need to put into the, okay, that's right. How much information does the certifying official need to put into the part that they complete in a U visa?
Very little. And what I do in my practice is I fill out everything I possibly can. And I do it by the charging documents, because they're going to ask what statute were they charged under, how helpful was the victim, let's see, what were the details of the altercation. Typically, in that section, I'll say, see police report. Police reports are very clear. If, let's see, I recently did one where the abuser had actually killed the child, and there was the whole trial of that, and the testimony and the plea bargain transcript. We included all of that. So that was referenced there. The certifying official needs to certify 4 things: that the crime occurred, that the victim was helpful, that
Damage? That they were hurt?
nope,
No?
nope, that they had been asked for help and were cooperating. If we've had some instances where battered spouses report a crime, and then when they're asked to come to court and testify, they don't want to. Well, you're not going to get a U visa certified if you're back with the abuser and you didn't show up at court and help police. The whole intention of this relief is to help police do their job and to get criminals off the street. And it's not just abusers. I mean, we're talking about, we've had robberies, we've had home invasions. In the Hispanic community, a lot of people don't use banks, so they carry around large amount of money in their pocket on payday, and there's an awful lot of home invasions and robberies that occur. Those are the kinds of things that need to be reported so that police can investigate, and they would qualify for this type of relief.
The certifying official or the head, I mean, I'm talking to the police department, they don't know. They don't know who it is.
That's true.
Chief of police?
It depends. Everybody's different. That's what's wonderful and crazy about our country. Who's the certifying official is this question. The certifying official varies by every police station. In Doraville, you need the chief of police to do it. In DeKalb, I might get the victim advocate to sign it. In Gwinnett, I probably have to get the DA's office to sign it. So it really just depends where you work and who you're used to and who you can talk to. If there's a victim advocate involved, if that crime actually went to prosecution, you're going to be 100% more successful talking to a victim advocate. So that's their job. They're there to help that victim. So you're going to start with them. If it was a crime that was reported and then they didn't prosecute for whatever reason, then the DA probably won't know about it and won't certify it. You're going to have to go back to the police station and see who's going to certify it there. Cobb County is almost impossible to get a cert from. I mean, it's the nature of where we are. So each individual county, each individual city, everyone's going to have a different person, and you just need to be persistent. Depending on who the victim is. Sometimes if the victim is very well spoken or very genuine in their telling of the story to me, I'll prepare the form as much as I can and I'll ask them to take it. I'll say, I want you to go back to that cop that you reported it to, because he's going to remember coming there that day. And I want you to ask, can you sign this? Or can you help me get this signed? And depending on the victim, they are sometimes more successful than I would be, and that's therapeutic for them as well. Do you have a question?
I wanted to find out if any if the Georgia policy that was recently passed, the immigration policy, has impacted.
HB 87?
How has it been? Yeah, how impactful has it been?
It's been horrible. It's caused a lot of people to leave Georgia, but unfortunately the states that surround Georgia have the same mindset that Georgia does. It was successful in stopping the consequences of someone who might be harboring or driving around an immigrant, so that was helpful. It's still up in the air what's going to happen with the rest of it. We've seen some particular counties who are already very strong with 287G. You know what 287G is? That's the agreement between the Immigration Customs Enforcement Police and the local police enforcement. They have memorandums of understanding where they would either train or place one ICE officer within that county to do specific immigration investigations. So those counties that already had that are using HB 87 to just expand. The counties who didn't, it really depends. There's a wide variety of opinions and a lot of feelings that go behind what's really occurring. So it's definitely made an impact. It's definitely made some people leave. It hasn't affected the certifications that I've seen, that I've tried to get. So I mean, I guess it just really depends. I haven't seen or heard yet that it's slowed down reporting of crime. I hope not, because that's going to affect everybody. But I think it might be too early to make a call on that, because it's just a month or so into it. Not even a month.
Okay, I have a question about a particular case.
Okay, no names, no
specifics.
specifics.
No specifics. Basically, we have a child that is Jamaican that came to the U.S. In order to be adopted by another relative, and the adoption was complete, and then that relative put the child out. And so the child has no legal status. She's in DFACS care. The reason they're saying that she came over is because they said she was engaged in prostitution in Jamaica, but there haven't been necessarily any confirmation of that other than what these family members that are no longer willing to take her in are saying. So I guess my question is, on the surface, you do have a child who's here who's illegal. She has been, I guess, abandoned by these people that adopted her and then said we don't want her anymore, and they're allegedly she was engaged in prostitution as a child, but we don't have confirmation of that. Would something like that, would that be hard to fit into this category?
That's the next category we're going to talk about.
Oh.
Hold your question
Gotcha.
for 1 minute, because there's a lot of red flags in your child.
Okay.
And that doesn't mean that there won't be relief, but there's red flags in that. Let's talk about what SIJS is first. Gotcha. And see if it qualifies. My first question, though, right off the top of the head is, where's mom's in Jamaica? Mom and dad?
Mom is in Jamaica. Dad was in Jamaica. He came here. He came here to get some medical treatment. I think he may have
humanitarian parole, maybe?
Permanent resident status or something like that. He did work here for a while, but the problem is Dad let the child come over and be adopted by his daughter, the child's sister.
Wow, that's a
so
hot
Dad
mess.
is no longer the biological father. Dad is now, I guess.
So they TPR'd mom and dad?
Well, I think that's where things are going. They're in the process of that right now.
Regardless of everything else you said,
right?
If they've TPR'd biological parents and adoptive parents do not want reunification, definitely SIJS.
Okay.
But
right.
there'll be some things that you'll have to overcome. So let's talk about SIJS. Special Immigrant Juvenile Status. Again, it's not for every kid who's in the United States. It's not a way that you'd want to trade your family ties for legal status here in the United States. That's not a good trade. Keeping families together is still a good idea when it's appropriate. This is for protection, though, of children who don't have lawful status here in the United States. They've been abused, abandoned, or neglected in the U.S. or abroad. It's very clear in the statute. The abuse did not have to occur here in the United States. It applies to children who've just crossed the border as unaccompanied minors and end up in the federal foster care or Office of Refugee Resettlement. And it applies to children who are brought here by family members. They may have entered with a visa. They may have been smuggled in. They may have came with mom and dad, brother, sister, anyone else. But they're here in the United States, and for some reason they can't be reunited with their legal custodians. That means biological mom, 100%, biological dad, if he was married to mom, or legal guardian. Okay? Doesn't matter if they're with brother, sister, aunt, uncle, friend down the street. Those are not legal guardians. This is an individual form of protection. This is not going to be an anchor that the child then petitions for mom and dad and everyone else later. This is one special relief for one special child. And it is complicated because it involves federal immigration law, international treaty law, and then 50 different state laws. Every state's different in how they interpret this. And the bottom line is that it's just one other ruling that you need out of juvenile judge. The federal government already said, we don't want immigration judges who know nothing about best interest in children to make these decisions. We want there to be a stable environment for that child to be in, to ensure that they're not deprived, to ensure that they're safe and healthy, and we want a legal guardian appointed. So the law is written specifically tasking the state judges, the juvenile judges, to have a deprivation hearing, have a hearing on the child, determine if they're deprived, and make these extra rulings. Here's all the laws. I don't need to read them to you, but these are all the laws that you have to look at when you're looking at a SIJS case. You have to start with the TVRPA. It's HR 7311. There's a new proposal this year for updates to that. This law protects trafficked victims, asylum seekers, and unaccompanied minors. You have to look at state law and define what abuse, abandonment, and neglect is, and then the best interest. Many times, if the child's here and you're going to send them back to the hills of Honduras to a home that has a dirt floor, no indoor plumbing, no indoor electricity, and the child can't go to school because the family's too poor and the school is too far away, that would be returning a child to a state of deprivation. You can't do it. Doesn't matter if it's in Honduras or North Tennessee. You can't do it. So you just have to look at this child right here and what you're going to be putting them into if you remove them from your jurisdiction. We also look to the best interests, the basic human rights under the Convention of Rights of the Children and Declaration on the Rights of the Children. That doesn't really work for anybody. The juvenile judges don't want to hear it. Immigration judges don't want to hear it. But those are still basic tenets that we should be looking at when we're looking at taking care of vulnerable children as a whole. Sure.
Can I ask a question while we're doing that?
Sure. If you grab that microphone.
I wanted to ask about the outside the USA. How did they confirm that that abuse occurred outside of the USA? I mean, what kind of legal status? Because I mean, somebody could come in and say, "This is what happened to me when I was in Jamaica." So, what do they have to be able to?
We'll talk about that.
Okay. Just going ahead. Sorry.
That's okay. So if we're looking at federal responsibility for juvenile aliens, it used to be as recent as maybe 5 or 6 years ago, kids were showing up at the border between the U.S. and Mexico and stopping at the border. They get caught by CBP, the Customs and Border Protection. They don't have status. They can't come into the United States. They were being turned around and sent back into the desert. Thousands and thousands of kids were dying every year, adults and children, in the desert because they weren't allowed to come in. And we didn't care if they were from Mexico, Honduras, Guatemala. You just can't come in. You had to leave. So there's a settlement that occurred that said that's probably not a good idea. It's probably not a good idea to turn kids away when you don't really know where they're going. So we established the Department of Homeland Security established the Office of Refugee Resettlement to take responsibility and care for unaccompanied minors. Unaccompanied means that they're not with biological mom or dad. If they're with biological mom and dad, then usually they'll all be detained, and they'll either be detained together and they'll go through the immigration process, or they would be NTA'd or given a notice to appear back in court and let free into the United States pending hearing. There's a lot of different things that would happen as long as there's a responsible adult taking care of that minor. It also used to be that before you could get a deprivation or before you could address the fact that there was a child who was deprived in your jurisdiction, you had to ask Homeland Security, can I do this? That happened for a few years until we realized that's kind of silly. They want to kick this child out. They don't want us to get this order. And so they were not giving permission to go to the juvenile court. And it was violating the whole purpose of protecting children. It was leaving children without legal guardians. They couldn't get enrolled in school. God forbid that they needed medical care. There was no one who could sign for them. So that was done away with as well. In 1990 is when they first created SIJS, and it really went for about 10 years when people really didn't know how to get this relief. Immigration lawyers didn't know anything about state law. Family lawyers didn't know anything about immigration law. We didn't know we could talk to each other. And so this relief just kind of sat out there, and we didn't know what to do with it. We didn't know how to help these kids. And it was also complicated to think, how am I going to explain to a juvenile judge in Polk County, Georgia, that he can have this child in front of him with a translator, and he can do a hearing on best interest, and he can decide that it's not in this child's best interest to be removed from the jurisdiction. It took a lot of training to convince the judges that they just need to treat this child like any other child who's come before them and make those best interest calls. In 1997, it's when we took away that specific consent from DHS, and that made things go a little bit easier. When you didn't have to talk to Immigration and Customs Enforcement and ask permission to treat this child who's vulnerable. That made things get a little bit better. And then in 2008, when the TVRPA came out, everything changed. It made it very clear that what our goal is to protect children. And what we need to do is whatever's going to be in their best interest, because children can't make good decisions. And so as adults, we should do things that are going to better their life. The important thing of the TVRPA is that their petitions now have to be adjudicated within 180 days. 6 months in an immigration petition is like speed lightning. And you think, well, that doesn't seem so bad. But I have kids who are now 26, and we're still on appeal because they applied when they were 15, and they still didn't get approved. So before this law took effect, the government would wait and wait and wait, and eventually deny it because they're no longer a child. And that was the reason. I'm sorry, you don't qualify for this relief because you're no longer a child. I know it's because we didn't do it in time, but I don't know what to tell you. So we're on appeal for those cases. There's less and less of those cases because the government's doing very good in sticking to these timelines now. It also prevents age outs. This is the key for DFACS workers, when you have children who are at risk for independent living, they're going to turn 18, they can't be under the jurisdiction of court anymore here in Georgia. We have to file that first petition, the I-360, before the child's 18. It has to be filed. As long as it's filed, their age is frozen. If the government wants to exceed those time limits, that's fine. The petitions are filed in a timely manner. As long as everything's appropriate, then that child will still get that relief as long as it's filed. Question?
Yes, I know that. In order for children in DFACS custody to be able to be eligible for special immigrant juvenile status, we have to determine that they have no viable resources. Am I saying that correctly?
We'll talk about what the requirements are. And it's not as complicated as everyone thinks initially. They're like, I got to do all these extra steps because they're immigrants. I'm like, no, you just got to do everything that you do in any other child. Go ahead and do your case plan. Go ahead and do your resource, the seeking of the parents, the grandparents, the aunts, the uncles. Do all that. Just as you normally would. We're still within those timelines. But at the point where you determine that reunification isn't going to be viable, that's when you need to start talking.
Okay, I'm gonna let you get to it, but let me just finish this part. It then goes back to there may be resources, but there may be resources in their home country, and then it goes back to whether it's considered the best interest of the child. Because a lot of times people's personal views get into play when it comes to sending the child back to their native country. Now, for some children who have never been to their native country, it's understandable, but a lot of times that happens, and so people make determinations on, I don't think it's best to go back there because education is better here, they have more opportunities, and I want to find out how you all balance that.
It's difficult. Every case is different. I think you need to not have a template that says, well, if they have 3 out of 10, then that's enough. I don't think that's ever right. I think every child is different, and every child will tell you something different. If this child's 15 and they've spent 9 years here, and the possibility of being returned to a distant grandmother they've never met is the best you can offer me, I don't think so. He's old enough to say he wants to stay here. On the other hand, child's 4 years old, and mom and dad were just deported simply because they were driving without a license, and kid got swooped up in DFACS care. There's no indication there was ever abuse. There's no indication that it's not going to be a loving environment to return that child to. I say you return that child. And there's proper ways to do that, and we'll talk about how.
One of the considerations with your question is that with these kids, it's often difficult to document what's going on in the country that they came from, because we generally have very little information from them. So it's even hard to track down, families, relatives, to find out exactly what is available, to the child. So I understand what you're saying, but it doesn't really come to that most of the time, because most of these kids are here. It's hard to track, their families in their homeland.
And we'll talk about in the instances where it's a good indication the child should be returned, there's already a process that the family should be going through back in their homeland, and their consulate should be involved. So they should really be coming to you. It shouldn't be that difficult for you to get the information when it's appropriate for the return.
What do you file by the time they're 18, before they're 18?
Before they're 18, we have to have a qualifying juvenile order, and we're going to talk about what all those requirements are. So hold on just a minute. I just want to talk to you about what changes the TVRPA made, because these changes made it easier to get the information that you needed before the judge and more comfortable for the judge to make those rulings. Filed by 18, the age is frozen. If they were still in proceedings, it was grandfathered. Like I said, the child who's now 26, still in proceedings, still in deportation proceedings for the past 6 years because they haven't made a ruling yet. It used to be also that we had to have a juvenile court order that said long-term foster care. Well, we don't have long-term foster care in Georgia, so I spent 90% of my hearing explaining to the judge that, no, I don't want this child to be in long-term foster care. I just want you to say he's eligible for it because there's no one else. And the judge's like, I don't know. So this kind of cut it across the board. What the statute was really looking for was a judge to say that reunification with one or both parents is not viable. And there has to be a reason. Not just because you don't want it. There has to be a reason. Abuse, abandonment, or neglect. I tell every young attorney who's interested in doing juvenile work with immigration, read the statute. It's very clear what qualifies. There's case law that ties to why you can't put a child back in a home with no indoor plumbing. It applies to Georgia as much as it applies to Honduras as it applies to Mexico. You're looking at Georgia law. And then it also removed the specific consent, and it talked about asylum relief. In this country, if you come here and you're afraid to live in your homeland because someone wants to do you harm, they're persecuting you on the basis of your race, your religion, your social group, 2 other reasons, you have to apply for that relief affirmatively within a year of entrance into the United States. This changed that for children. Children should not be held to the same standard as adults when they're minors, under 18. So this changed that. They no longer have to meet that 1-year filing deadline. So if a child was brought here, and for some reason, we've had a few children, came from Colombia, children of politically active parents, and for some reason they're no longer together, they can then apply for asylum once they reach the age of majority, and without that restriction. And the other good thing is that the asylum office has jurisdiction even if they were previously deported. What we found when we first started doing this, we'd get kids who were in care, and maybe they were caught at the border with their parents, and they were put into deportation proceedings, and then instead of staying in Texas where they were caught, Dad took the child to Georgia. Never showed up in immigration because he knew if I show up, I'm going to have to leave. But then he abandoned the child later on. Well, I'm in an SIJS interview saying, well, this child's been in DFACS care for 3 years. We'd like to get him adopted. It's a good candidate. And the officer says, but the child was deported 3 years ago because they didn't show up to court. So this is a way that we can undo those deportations in absentia because the child didn't have a choice whether to show up or not. This is the important part. This is the important part for when you're talking to judges and the judge says, well, I don't want to make this order. I don't want to keep this child here. I just want to make an order, and I want you to drive this child to Hartsfield, put him on a plane, and put him on a plane to Mexico. Because I know there's an aunt there because you talked to her on the phone last week with a translator. That can't happen anymore. TVRPA specifically said that Congress's intentions were to protect vulnerable foreign-born children, and we have to enhance the efforts to combat trafficking, and we have to ensure safe repatriation when it's appropriate. That is not an appropriate repatriation when you put a kid on a plane with a Delta $100 stewardess and gets off the plane somewhere else with somebody you don't know. That you don't know what kind of place they're returning to. You don't know the house, you don't know the school, you don't know whether they're going to still be in a state of deprivation. The law was very clear that the Secretary of State has to negotiate agreements between the U.S. and the contiguous countries. There's still not an agreement between Mexico and Canada on how we're going to repatriate their children who are found in our country in a safe manner, much less how we're going to repatriate children to countries that are more removed than that. It specifically said that no child shall be returned to the child's country or nationality of last habitual residence unless they're returned through appropriate employees or officials. through proper diplomatic channels. What happens? Mom and dad were deported, child caught up in defects. They're back in their homeland now. They're in Guatemala. What they need to do is they need to go to their it's called Ministerio Público, their interior diplomatic channels, and they need to say, look, here's my deport order. I was living in Georgia. I have 2 American-born children. I want them to come back to me, and so you need to help me. So their government will contact our government, who will in turn contact the local consulate office. In Atlanta, we have Honduras, El Salvador, Mexico, Guatemala. We have all the major Central American consulates here. And they would then come to DFACS. They'd provide you with home studies. They'd provide you with all the information that you need to do your job so that you can go to the judge and say, these parents didn't abandon their children. It wasn't their choice to be caught up in an ICE raid and be deported. They want to have them repatriated. Here's the proof of why they should be. Then the judge can turn them over properly, and they can be repatriated. If that doesn't happen, you can't put them on a plane. We had judges writing orders like that. And the TVRPA said we need to implement best practices to ensure the safe repatriation. And that means that we have to do assessment of country conditions. Our government each year puts out a country conditions report on every country in the world. It talks about the likelihood of child trafficking, it talks about education, it talks about all sorts of things in each area. There's also Department of State country reports, there's human rights reports, and trafficking in persons reports. There's a lot of independent research on there about where that child would be going if you can't get specific family information. And I can tell you there's not a DFACS agency in Guatemala. There's not a DFACS agency in El Salvador. There's not even a DFACS agency in all parts of Mexico. A couple parts there are, but Mexico also has the biggest influx of las SIJS and organized crime, and they're specifically targeting children who don't have strong male figures in their family. So there's a lot of reasons why you can argue to keep a child here if that's what the child wants and it seems appropriate. The other important thing that the TVRPA did is it talked about state reimbursements. It says that any state agency who's providing care to a child needs to be reimbursed on a federal level. I was jumping up and down when I heard this. And guess what? I don't know where the form is. They keep telling us that the Trafficking Victims Reauthorization and Appropriations Act, you would think appropriations had money. I would think. We don't know where it is yet. But it says that there's all this federal financial assistance eligible moving backwards. So if you've had a child in care for 3 years and now they eventually become legal through SIJS, you should be reimbursed for that. We're still monitoring it as soon as it becomes available. I promise I'm going to make sure every DFACS agency gets reimbursed because y'all do a lot of work. And I know it doesn't come out of federal or state funding, it comes out of your county funding. The other good thing though, not retroactively, but moving forward, we file the SIJS paperwork. Within 3 months that child gets a work permit, no matter how old they are. I'm not child trafficking or child labor. But we get that first federal ID through a work permit and their social security number. Children are exempt from the restrictions on public benefits. So anyone under 18 can tap right into federal and state benefits. And you should be loading them just as any other kid. You get that social security number and that work permit, they need to be getting their benefits right away. I know there's certain counties that are being told no. I know there's certain counties that can never get it. I'm asking, there's 169 counties in Georgia. I don't know why 160 of them are getting them. So that's something that somehow needs to be worked out within Georgia. There's some other issues. I know sometimes when kids don't have proper parental supervision, they do silly things like commit crimes. If the child is under 17, under 16, and it's a delinquency, we can usually deal with that. Not probably going to be a problem. I'm going to have to see a certified disposition of that delinquency action. And we're going to have a lot of explanation if it's a bad one. But it's probably not going to be a problem. If you have a child who has a long line of 17-year-old activity, that might be a problem. It might make them inadmissible. Doesn't mean it's going to make them inadmissible, but it's something that you're going to have to properly address before you submit those applications. The minute you put that child before an adjudications officer and you're pulling out all these dispositions that then make them inadmissible, if that child's 18 now when they're having that interview and they're not going to be able to adjust, they're going to probably be taken into custody right then and put into deportation. So make sure that you know the child is going to be eligible before you put them in that situation. The TVRPA talked about things that are specifically waived. Like I said, the delinquency, public charge, labor cert, being present, which means they're here unlawfully, regardless of how they got here. Misrepresentation and fraud. We see a lot of kids who come in who have US-born brothers and sisters because their parents came to the US. And so they'll send their US-born brothers and sisters passport or birth certificate back to them in their homeland, and they'll try to cross with that because they look similar. Well, that's fraud, but it's not going to be held against a minor. So as long as they're under 18 when that occurred, that's not going to be a reason to not adjust them. There are some things that are waivable. Prostitution. If for some reason there's hard evidence that a child was involved in prostitution, we can do a waiver. And that's literally a form that you just say, forgive this. This was a child who was caught up in this criminal activity, and so we need to waive that activity. But I would not ask the government to waive anything that doesn't have proof. And to me, proof is criminal dispositions. I don't care what kind of allegations would happen without any actual proof. I don't feel obligated to do an extra good job for the immigration to tell them about things that could or could not be true. Alcoholics, mental and physical disorders, drug addicts, abusers, even association with terrorist organizations. We have, a few years ago, we had the Lost Boys of Sudan who were involved in terrorist activities within their country. And George Washington might have been a terrorist had it gone a different way. So there's all sorts of things that we can waive, but you really need an immigration attorney to assess the situation and hear all the information before you get before an immigration official. Not waivable. Certain crimes, aggravated felonies. Aggravated felonies for immigration are different than just felonies under state law. An aggravated felony could be anything that you receive a sentence or could receive a sentence of more than 12 months, and they actually did receive a sentence of 12 months or more. So if you're talking about an aggravated battery done when he's 17, if he was given 12 months jail time and 3 years probation, that's something we probably don't want to be applying for. So it's something you have to look at. Also, multiple criminal convictions. If we have maybe a battery and a few driving with no license and some mischief, those are things that we're going to want to look at before you get before an immigration official who's then saying, I don't think that this is approvable because I don't think you have good moral character. Controlled substance traffickers and terrorist activities, bars. If you have a child who has actual documented evidence of being affiliated with gangs, drug trafficking, terrorist activities, don't ever do these applications. There's no way to waive those. Possession of 1 ounce or less of marijuana, we're probably going to get around. Anything more than that, not looking so good. You're going to hope that they're 16 or younger. And that's not to say that maybe there's a story that doesn't go behind that. We had one case recently where the 2 young boys were being used as mules from the parents to traffic. They were too young to know what they were doing. And there was a way that we could get around that.
Thank you all so much for returning from the break. We are going to continue with the presentation. I hope everyone's enjoying it thus far. And just a reminder, please fill out your evaluations, and also if you need a parking validation, pick up the validation before you leave at the table out there with the students. And just a reminder, if we could please try to use the microphone, it would be greatly appreciated. I will try to get it to you as quick as I can. So thank you very much, and thank you.
Thank you. Okay, so now let's talk about special immigrant juvenile status. And we're talking about 6 basic requirements. Everyone can break down a list to 6 points that you can follow, and then it's not so hard. The first requirement, the child has to be under age 21. And that means that the federal eligibility criteria has been extended up to age 21. However, in the state of Georgia, we really need to get this first petition filed before 18. Because in Georgia, as much as I've tried to fight it, and I've tried to stretch it, and I've tried to connive judges that sure you can keep jurisdiction, bottom line is Georgia law ends jurisdiction at 18. My biggest argument was for extension of jurisdiction is that the juvenile law is one code, and then we have deprivation, and we have delinquency. Delinquency is very clear that the court can maintain jurisdiction up to 21 to effectuate the plan. My argument was always like, why would you reward people who do something wrong and penalize people who are victims? It works sometimes, not often, so I wouldn't rely on it. If you have a child who you're going to propose is eligible for this relief and you're going to try to get a deprivation order, get that order and get the first petition filed before they're 18. What we said was the TVRPA resolved this. We thought it was going to resolve it. We thought that every USCIS office, or the United States Citizen and Immigration Services, what I call the benefits section. We have Department of Homeland Security. It's like a three-legged stool under that. We have CBP, or Customs and Border Protection, which tries to keep people out. We have EOIR, or Department of Homeland Security, ICE Immigration, which tries to kick people out. And we have USCIS, that is the benefits section. So this one little leg here on the three-legged stool, we thought that they were going to speak with one voice, and we thought they were going to say, as long as that child was deemed deprived and you had everything in that order before they were 18, we'll allow them to become an adult at 18 and then to apply for that up until age 21. We thought that's how they were going to interpret it. That's not how the Atlanta office is interpreting it. Some other offices throughout the country are interpreting that way. And it's something that's ripe for a fight here in Georgia as to why the government wouldn't speak with one voice. But right now, the way it works in Georgia is you need to have that first petition, the 360 filed, with the qualifying order before the child turns 18, even if it's a day before. He's frozen at that age. Child has to be unmarried. If this child has children of their own, that's okay, that's not a bar. Typically, I would imagine they're going to be US-born children, not always, but they cannot be married. This is a difficult one when you work for a Catholic organization, when you have to tell people, I know you're pregnant, but if you're even thinking of staying here while you're pregnant and having that baby and remaining in the United States, you can't get married. So if you have someone in that situation, make sure that's one of the cautions that you give them. The child has to be deprived under state law. They have to be declared dependent on a juvenile court located in the United States. They have to be under the custody of an agency, a department, or a guardian. So it's okay if they're in DFACS care and they're placed with a foster parent. It's okay if they're with DFACS care but they're placed in a guardian situation with an aunt, uncle, sister. And it's also okay under Georgia law to do a private deprivation where DFACS isn't involved at all. And we get a lot of those where children are just with family members, not biological mom or dad, but with a different family member. And they have no legal right to that child or no legal obligation. So we would do a private deprivation and they would be deemed deprived first and then in a guardianship situation. Number 4, this is where it gets difficult. This is where your lawyering is going to come in. You have to put enough evidence before the judge to show that reunification with one or both of the immigrant's parents is not viable, and it has to be due to abuse, abandonment, neglect, or a similar basis under state law. So you have to read the law. You have to figure out why that child can't be reunified with that parent. This doesn't require that the court address both parents, and that's something really important for my target audience. Typically, 80% of my cases are Hispanic. They're from Central America. They don't typically get married there. So we have biological mom and biological dad who's reputed. He has no rights to that child. He's not supported the child. I don't even know where he is. How am I going to serve him? To get jurisdiction, especially on the private cases, to get that child before the judge, I have to do proper service on somebody. I have to do publication, or I have to get proper service on biological mom. And what we do is we contact the biological parent back in their homeland. We work with an attorney in that homeland. We properly serve the biological mother. She goes before that attorney, signs off whether she's in agreement or not, whether she wants the child back or not, whether she's distancing herself from the proceedings or not. The attorney certifies that and returns it to our office, and we present it to the judge. And that way we have proper service. It does not require that we terminate parental rights. That's a huge one. That's different. If this child's in defects care and you have to look towards permanency, you'll probably want to do that later on. And that's something we can help with as well. We've helped with other cases with that. If the true goal is permanency and that child is never going to be reunited due to this abuse, abandonment, or neglect, then you'll want to go ahead for the TPR. And it's a complete packet that we already have translated as well through your forms. This doesn't mean, though, that if mom and dad both came here unlawfully and dad abused the child and the child was put back with mom, that the child's going to qualify for SIJS. Because if you read the Georgia Code, to be deprived under Georgia law, you have to not be in the custody of your biological parents. If you're living with your biological mom, the judge is not going to make a deprivation ruling in that case. And that's the first hurdle. It has to be deprived, and then reunification with one or both parents is not viable. In some other states, their law is written different than Georgia, and one-parent SIJSs is what they're being called now, work. It works. I don't personally think that's a good idea because you're then giving status to a child, placing them in a home with a parent who doesn't have status. That's not going to be a good, a good, firm, stable environment for anyone. I think U-Visa would be a better way to go in that case. And that's a way that you can keep the family unit together, but give them the status that they're going to require to be stable. The best interest remain in the current placement is how I tell judges this is the ruling that we want, because that's what I think they're used to hearing. That's what DFAC says. DFAC says it's in the child's best interest to stay in that foster home. It's in the child's best interest to stay in that treatment facility. And that's what I want the judge to rule on here. I want him to say that it's determined that it would not be in the child's best interest to be returned to their homeland. Judges don't like that. I'll tell you right now. They don't like saying something's not in the best interest. They feel very comfortable saying it, what is in their best interest. The TVRPA used to say that we had to have findings of law that said this. Now we can have it in the findings of fact. So if the judge would agree in your order that you put within the findings of fact that due to all these reasons, the father was deported for trafficking cocaine, the mother abandoned the child at age 3, maternal grandparents may be available but unknown, the child could be returned to the family home, but it's unclear as to whether there's appropriate water in the home or there's appropriate education. All the reasons that you put in the findings of facts about why reunification to that homeland wouldn't be a good idea, then the judge can make the ruling that it's not in the child's best interest to be returned due to those facts, due to the findings of fact. And that's how we usually get the judges to understand why we'd like them to please speak federal language in their state order.
I just wanted to add, because I worked with Rebecca on a case that I had. This is a lot of information, and I'm a child attorney in Fulton County, and Rebecca was very helpful. There's 2 levels here. There's making an argument in the federal court, and there's making an argument in juvenile court. And all of the things that Rebecca's talking about in terms of the language, she was very helpful in providing us with, sample orders so that from the very beginning we could start having the judge include in our juvenile court orders the language that was needed to support, the federal stuff later on. So the bottom line is that get her card. She will walk you through all of this at the level that you need to be walked through in juvenile court, and then she was retained by DFACS to represent my client in, the federal court. And so it's a lot of information, but it's not a lot of information that you have to know yourself in order to represent the child in federal court. You just need to know who to talk to and what language that needs to be included at the juvenile court level, again, to facilitate Rebecca's involvement later on. So because we get overwhelmed by all this information and all the federal, but get her card.
And thank you. That's true. I mean, this is kind of like the Cliff Notes. It's not the playbook. The playbook is like this thick. Because you're dealing with just very complicated sections of the law. You all know juvenile law is so complicated. Immigration law is so complicated. If you submit an application and you forget to put NA on one block, that's not a properly filed order. And if you filed it 2 days before the child turned 18 and didn't do it right, and it got kicked back, you just lost that child's chances. I mean, it's that serious. So, exactly, we have sample everything. We'll probably give you too much information. But we want you to have enough where you understand the argument. We've also appeared as friends of the court with DFACS to help to explain to the judge what portion of this order we're asking you to rely on these types of reports and why. And that's been helpful. And look at number 6 doesn't even apply anymore. So really you only have like 5 things to remember when you're talking about the juvenile orders. Like she said, the juvenile orders are very specific. We'll give you the findings of law as they need to be written. It's easier for me to explain to a state judge why I want him to make this ruling a specific way than to argue for that kid maybe 180 days later in front of immigration why, when the judge said this, he meant it was close enough to that, and then risk the chance of that being denied. So it's much better if you give an appropriate order starting out. Did you have a question?
Okay, I'm sorry. Okay, I do reviews for state office. And so I was reviewing a case in one of our local counties, but this has been about 2 years ago, and I was so about to die because it was a child, stop laughing, Joan, from Mexico, and the agency had not done the appropriate work so that when he ages out and turns 18, my concern was he wasn't prepared to be a citizen. And he was going to age out. And at the time, I didn't even know about the SIJS. I mean, of course, I was throwing out all these things and trying to get them to get somebody else at the state office that does immigration. But this child now, so he aged out, illegal, and then we just dropped him. So it's 2 years ago. We can't go back and do anything for this child. He's a legal adult now.
Probably not, and that's what my new fight is. I always need a fight. My new fight is with the USCIS Atlanta office and their interpretation of the TVRPA. Because my interpretation is if you had all the rulings that you needed in an order before you were 18, you have up until 21 to apply. And I think that we need a good case to challenge the Atlanta interpretation of, or application of that. Because Atlanta has chose to say, no, Georgia law, jurisdiction ends under deprivation at 18, so if that kid doesn't file by 18, I don't care what the federal statute says, I'm going to hold it at 18. If that child was in care for longer than a minute, if that child was in care for a good long time, there's a lot of evidence in there why he was a vulnerable child. He didn't stop being a vulnerable child when he turned 18, he got more vulnerable because he's not eligible.
Because he wasn't prepared to live here.
Right.
And he was not going to get a job, benefits, and all that.
And just one other clarification, this does not get children citizenship. You don't go from undocumented, and if you can all start saying undocumented, everybody together, undocumented. It's so much less harsh than illegal. If you go from undocumented, you don't go directly to citizenship, okay? You go from undocumented to a legal status, to permanent residency, to proving your ability to become a citizen. It's not a gift. I mean, you have to qualify for residency. You have to then pass a test and prove your worth to become a citizen. But that child who was in care for such a long time, that may be a good candidate to challenge the interpretation here in Atlanta.
With regards to that child, he aged out at 18, but if he signed himself back into care, which keeps him in DFACS custody, could DFACS still not continue to assist that child because that child is still considered a ward?
These are like great minds thinking
of the
alike.
state.
That's my argument. My argument is that if the child's still in independent living, DFACS still has them under their care, then some agencies say no.
Pardon? Well, I mean, when you're in DFACS custody, when you get to be 18, you have the option of signing yourself back into care. And he's
Yes.
still in DFACS.
Yes,
If
the
he's
way
a-
the DFACS manual is written and the way a recent court case went, DFACS must offer independent living. If they offer it to an undocumented child and the child accepts, and then for some reason they deny to go forward with that, that's their discretion. We can't do anything about that. But if you don't offer solely because that child's undocumented, you've broken your regulations.
I have a question. If that child should move to one of the areas where it is 21, if
Alabama,
that child
19.
should move to an area where the age is different and the child is still within the age range for that jurisdiction, then does Georgia law still control?
Nope.
So
It's
if that
personal
child,
jurisdiction wherever that child is. And we've somehow managed to move a few children to Alabama. Alabama DFACS is very kind. They'll port cases in some instances. There's a boys ranch out there, and that's been successful. There's more than one way to skin a cat. But I really think the bigger issue is that we need to have, if we're talking federal law, we need to speak with one voice. The federal government writes these, the Congress has written this law very specifically. If they had wanted it to vary by state, they could have wrote that. But they said, children are children until they're 18. Now we need to give them just a second to settle and to realize that there's options and to apply for these benefits. If you're going to cut them off, if you're going to cut off that first hurdle and not even let them apply for those benefits, I have a very big problem with that. There's someone back there with the microphone.
Hi, I have a question about a child from an Eastern European nation adopted by a U.S. citizen father, a non-U.S. citizen mother, and came into foster care. And now the U.S. or the non-U.S. citizen mom has relinquished her rights. The U.S. citizen dad is in the middle of TPR proceedings, and this child acquired citizenship through the Child Citizenship Act, which means it came through the father. And I'm curious how that works when the rights are terminated. Could you speak on that and tell us what we should do?
Number one thing, that if you take nothing else today in your DFACS worker, do not get these children adopted out until you address their immigration status. Because I'm not going to get a deprivation ruling, and I'm not going to fix the fact that they entered unlawfully if they've been adopted. Because once they're adopted, they're no longer deprived. So the judge can't even take jurisdiction and can't make the rulings. So if you have, pardon?
Can they be deported then?
Yes. Yes. And it most likely won't happen when they're 5, but it's very much going to happen when they're 18. Okay? Let me answer that question first, though. So her question was, child came in and was adopted properly, I'm hoping, although international adoption is very difficult, and there's a lot of things that have to happen with the Hague and with the immigration to make that adoption effective. I'm hoping, let's assume that that was all done right. Child came in with a permanent resident card as a derivative child of a U.S. citizen. There's a few other hurdles they have to pass to see if at that point, once he made a legal entry into the United States, if that derivative citizenship was passed to the child. Typically, the child has to be under 16 and has to live with the adoptive parent for 2 years. There's some other regulations that the adoptive parent has to have resided in the United States for 5 years after his 16th birthday too. I mean, it's just crazy. They write it down. I have to look at it every time. But instead of worrying about that for that child where there's other history, and whether you're going to be able to obtain documents like a birth certificate or like that original permanent resident card or any cooperation from the adoptive parents, that child now is in DFACS care, right? That child's now deprived. Throw that away. Do SIJS.
Would it be helpful if they attempted to reach the parents to just see if they do have any green card, passport? There's nothing in the DFACS file.
The judge can order that they present the documents. DFACS can't. I've never had a case where that was successful. The only thing that could probably happen that would be helpful is that the adoptive U.S. citizen father would apply for a passport on behalf of the minor child. The passport would come, but now you got another issue. Now the child's a U.S. citizen with one name. What's going to happen when you get him adopted out? Now you're going to have another thing. I mean, that's something you're probably going to want an immigration attorney to investigate much more thoroughly, because I'm hoping that child came in lawfully. That the difference between entering the United States lawfully and unlawfully is like night and day when you're talking about what your future is going to be like. My worst thought on that would be that if for any reason that adoption was found to be not sufficient and the citizenship didn't pass, and you didn't find that out until after the child's 18, you can't go back. You can't go back and fix that. So I would want to make sure that that was done in first. Okay? There was a few other things with jurisdiction. This is how the Atlanta immigration benefits section isn't saying that they have to have jurisdiction over the child to finish these applications. They're saying that the child has to remain under the juvenile court jurisdiction the entire time that the immigration applications are pending. But the TVRPA said that's not applicable anymore. So two parts of the TVRPA in my book say that they're reading the law wrong. They're applying the law wrong now as it stands. And the people at the local office aren't bad people. They're good people. I mean, they're just doing their job. But the mandate that they're getting from above is these are our hard, fast rules. And until we challenge them, there's a lot of kids who are going to miss out. So let's kind of look at the SIJS process. We're talking about a child who's in state dependency proceedings. I was involved with the rewrite of the Georgia Code, and they asked, do you want us to have a special section just on immigrants? I'm like, no. I don't want you to be like, okay, you over here, and you over here, and I'll do you this way, and I'll do you that way. No. I want you to have one juvenile code that talks about all kids under 18. I just want you to treat them all the same. Separate but equal never worked. So I want you to address these kids all the same. So when you're in the state dependency proceedings, you're just talking about a kid who's before the judge because they're deprived. You're going to make special rulings based on that case. If the child's in defects care, there has to be special rulings made every 6 months for your federal offending, right? Well, that doesn't happen in private cases, so I don't ask for those rulings. It's okay that you do. It's the same thing I tell a judge. That child over here who was born in the U.S. doesn't need the reunification to his homeland isn't a possibility, because this is his homeland. But my child does. So let me put my evidence before you. Let me put it all on the record. Let me convince you or not convince you what the situation is with this child, and then you make the ruling. If the judge goes my way, I'm happy, I get my order. If the judge doesn't go my way, then I have an appeal process. That's the process. It doesn't matter what the child start as. I don't want to be frisking kids at the front door and be like, well, it looks like you're going to be hard because you don't have a birth certificate and you weren't born here and I don't know what to do with you. No, I mean, it's a vulnerable child in care. We need to address the situation. One other separate thing about the dependency proceedings as it applies to immigrants, though. Typically, I would assume any case that you have before you have a birth certificate in the file, and that's how you know how old the child is. You have school records. A lot of these kids left their homeland and didn't bring their birth certificate. I don't know what they were thinking. So they get here, and they don't know. They don't know how to get it. They're minors, so the consulate's not going to give it to them. There's no parent there to ask for it, so we can't get their birth certificates. Originally, we couldn't get them at all. But now we have such a good relationship with the consulate, we can usually get them if we need to. But this is one of the few federal regulations that are written where a birth certificate is not required. For every other immigration relief that you apply for, you have to have a birth certificate. For this one, you don't. If we can get the juvenile judge to rule the child's name, date of birth, and location of birth within that order, then that's sufficient for immigration. And you can do that through testimony. We've had one young child that we had to do through testimony for dental records because they came as a refugee. So any way that you can be creative to do that. We had pictures of birth dates, and we just had all this different evidence. But most judges, when you get someone who's not little, will take the testimony of what year did you celebrate the birthday and what day, and so you get those rulings within that order as well. And then if for some reason the child's here and immigration doesn't know about them, because there's a lot, then you go right to what we call a one-step. You have that qualifying order with the 4 rulings that we need, and it's certified, and you file all these immigration paperwork. And it's a little more complicated than the list, but you do that 360, which is saying, hey, I'm an immigrant kid, and I'm in the United States. You do the 485, which says, I'm an immigrant kid and I want to stay in the United States. You do the 765, which is the work permit. No matter how old they are, I do a work permit because that's your first federal ID in 90 days. You do I-131, I rarely do. That's authorization to travel. I think if you got here and you're lucky, you're not leaving. There's no reason you need to be leaving. A G325A, that's biographical information, lists mom and dad and where you've resided. It only applies if you're 14 or older. And sometimes kids don't know the answers, and that's okay too. But you have to submit it and you have to write unknown or NA. Birth certificate if you have it. If not, then the information in the juvenile order. Medicals, you have to have an immigration physical, and never fails. Everyone says, oh yeah, the kid had a physical for school. Well, that's good, but now he has to have an immigration physical because you're dealing with the federal government. They want you to go to a specific doctor. They want you to pay an exorbitant amount of money for one little piece of paper and listen to his chest. If you have shot records, which every kid in school has shot records, take them with you to the immigration doctor, and it'll save you at least $100, $150. We have a list of all the qualifying civil surgeons here in Georgia, and I can point out to you the ones that are reasonable. Costs $1,010 to get permanent residency for kids. Everyone went, but wait, there's a fee waiver. And knock on wood, we've had 100% success in our fee waivers for SIJS petitions because guess what? They're undocumented juveniles who can't work, who has money. So the government's been very generous in approving all those fee waivers, and we haven't had to pay for the documentation for the kids. So you have to pay for the medical. You maybe have to pay for Catholic Charities or for an immigration attorney to do the immigration work. But then the immigration process, you don't have to. So then you send all these documents off. We need 4 passport photos of the kid. We send all that documentation off. And within a couple weeks, you'll get a receipt back where the government says, yes, Juan has his paperwork filed. It was filed on this date. His birthday's this, so we know that he's under 18. And we'll get back to you. So if we didn't file that 765, the work permit, we'd be waiting up to 6 months to hear the next word from immigration. But because we filed that 765, within a month or so, you're going to get an ASC notice. And what that is you have to go down to the local immigration office and have your fingerprints and your picture taken. But the minute you get to the door, they're going to say, give me your federal ID. And all these kids are going to say, what? Yeah, I don't have a birth certificate. I don't have a driver's license because I'm 12. I don't have a federal ID because I'm a kid. And so we made an agreement with the local office that we provide a voucher saying that we're representing this child. They're in care and defects, or they're living in this situation. Here's a photo of them. It's very official. I put my notary stamp on it. So here's a photo of them. If it looks like him, will you go ahead and take his fingerprints? And luckily, they've been very gracious, and they've agreed to that as well. When you do that, within another 2 or 3 months, you'll get a notice that says, hey, you need to bring that child down to immigration. It's on Park Lake Avenue over there in 285, and we have to have an immigration officer interview the child. Most of the kids, if they've been here a while, speak English. If they don't, you're going to have to bring a translator on your own. And you probably want to take your immigration lawyer. And if you did a good job submitting all the paperwork and everything's absolutely right, your interview will probably take 5 minutes. They're going to go through it. They're going to say, is your name Juan? Do you live here? What's your birthday? Where's your mom? Where's your dad? Simple questions through the petition. If the child's over 14, they're going to run their FBI fingerprints from that biometrics that they took. Any delinquency that comes up, we're going to have to give certified dispositions. I give them up front because I want you to know about it. It's not going to hurt me, so I want to know about it. If everything goes well, you'll get a letter that day that says, welcome to America. You're a permanent resident of the United States. Within 3 weeks, they'll get a green card. And for a while, they were red, but now they're green again. So a fancy little credit card with their picture on it in 6 different places. And it has their name, their A number, their date of birth, their country, and their code. SL6 is the code that they'll be given. It's special immigrant, juvenile status, and that's the benefit they receive to receive the permanent resident card. The permanent resident card is good for 10 years. It's renewable in 10-year increments. So a child's 5. If he wants to wait, and when he's 15, he'll have to renew it one more time. And then as soon as he's 18, and he's resided in the United States for at least 5 years, he can apply for citizenship. And everyone who's in the United States who's male, who's 18, has to apply for selective service. If you don't do that, that's going to be a bar from you becoming a citizen. A few years ago, I had one local school who said, well, we should just help all these kids. We'll go ahead and we'll register them to vote, and we'll go ahead and we'll register them for selective service. Yeah, that was my face. Not good. If you want to vote, you have to be a citizen. So a whole bunch of these immigrant kids got registered to vote when they weren't able to. Again, another bar to citizenship. So we undid that. So, 18 and over, 18 to 26 men have to register for selective service. They don't have to join. In fact, they can't anymore. Registering to vote, you have to wait till you're a citizen. It's a little bit different if the child's in removal proceeding. And we have some kids in removal proceeding. The child has to go to 2 different courts. They have to attend the immigration removal master calendar. And it's not like you can do a conflict letter. It's not like it can be inconvenient for you to get there at 8 o'clock in the morning and wait till 4 to be seen. It's cattle call, 80 people on the docket, all jammed in this little room, and you must attend. You have to attend. No excuses, less than death of you or immediate family member. They also have to do the dependency proceedings. We can get continuances before the immigration judge if we're pursuing special immigrant juvenile status and a juvenile court order. The judge is very reasonable. We have a dedicated juvenile docket. We just got a new judge. It's a female judge from Florida who was in private practice. Very reasonable. I'm hoping that she's going to be as reasonable as the auctioneer from Tennessee we had before. He was wonderful, big old teddy bear. But in dealing with the juveniles, they take a special, slower pace, and they'll give us the continuances we need. But we shouldn't need that much. I mean, you shouldn't really be seeking a deprivation and a guardianship petition that takes longer than 3 months. I mean, that's a long time for a kid to be without a legal guardian. So it shouldn't take that long. Once you get that, you'll file that 360, that first one that I told you had to be done before they were 18. You'll file that, and you'll wait. And then you'll go to court next time, and the judge will say, well, what's going on? And you'll say, well, I got this receipt that I filed it, but it's been 3 or 4 months. I don't know what's going on. And the government counsel will go, oh, here it is in the file. And you'll say, oh, gee, could you send that over to the benefits section so it could be approved so we could get out of deportation? And they do. Once you get the approval on the 360, and again, that's just raising your hand saying, I'm an abused or abandoned child, I have a qualifying order. That's it. No benefits there. Once that gets approved, you'll have to do a motion to terminate, which means you're asking the judge to stop trying to deport this child. He's been deemed eligible for relief. Now we're going to do the 485 and adjust their status to a permanent resident. You take it out of the deportation process and you put it back into the benefits section. Remember the 3-legged stool? Out of deportation, back into benefits. Then the same process. You file the paperwork for that. You'll get your biometrics taken. You'll have your interview. The bad thing is that your 180 days doesn't start until you file that 485. So you're really looking probably 9 months, maybe 10 months. They're pretty good at terminating the kids' cases once we show eligibility. And again, same thing, age 18, if you've been a permanent resident, LPR is legal permanent resident, for 5 years, they can apply for citizenship. This is a cover page that we do. You can do whatever you want, but Immigration and Customs Enforcement. Those are the officers. And we say TAs, the government counsel. I mean, it's a courtroom. It's an administrative proceeding, but it's a courtroom. So you're on one side with your client, the trial attorney, the government counsel is on the other side, and the judge is up front. Surprising enough, they both work for the same company. I don't understand it. But where you file all these petitions are in Chicago. And if you don't put a cover sheet on all your petitions that specifically say what's inside and it's for special immigrant juvenile status, please rush, they won't. If you don't put a note on the outside of the envelope, do not open in mailroom, special immigrant juvenile status. They'll open it and they'll send it back to you because they don't know what it is. It happens every time. If you do put the thing on the outside that says fee waiver, do not open, special immigrant juvenile status, it'll go to the right place and you'll get your receipt. So do it. I know it sounds silly, but do it. And what I usually do is I specifically put everything that's in there. You have to have a notice of entry of appearance as an attorney. It's called a G28. You have to have petitioners, photos, the sealed medical exams. Don't open those medical exams you paid $150 for. They have to be sealed and they have to be opened by immigration. All your petitions, your birth certificate, if you have it with the translation, any foreign document has to have an English translation certified. The juvenile court order with the certification. Depending, you know, if I have a kid who has quite a long delinquency record but really good grades, I'm going to put school records in there. I'm going to put pictures of him in there. I'm going to put letters of support from the community because these are discretionary reliefs. So you want to make sure that you balance it all out. This used to be the fee waiver that we did, but now they have a new form. It's called I-192, and the government has the standard form. You put the child's name. You put that they're a ward of the court, that they are unable to work, they don't have any money, and they've been granted. Some pointers. Prepare well in advance. Don't wait till the child's 17 and 9 months. If you have a child in care, and even if the ruling that the judge wants to make is that reunification is concurrent with non-reunification, or however the judge wants to do it, that they may be pursuing some type of reunification, but at this time, reunification with one or more parents is not viable. That's worked. And that's in cases where maybe mom's working really hard to get the child back and they had a failure to protect, but in most times we've seen mom goes back to the abuser and the child's not going back. But your time is limited to get this approved for the child. Know your juvenile court. There's things that I can do in Cobb County that I can't do in Fulton. There's things that I can do in South Georgia that I would never be able to do in Gwinnett. So know your court, know your judge, know your SIJS, know your DFACS workers. I mean, it's all about what we're trying to do to help this one child. And it's not personal other than the fact that we want to help this one child. I don't care about, the 50 million other kids that you're worried about. I'm only worried about this one right here, right now, today, because this is his day. And like I said, juvenile delinquency, deprivation, we have to have certified dispositions. Any criminal activity. Delinquency is not criminal activity under the code. So any criminal activity, 17 or over, you're going to have that assessed to see if it falls into a category that would bar adjustment. I think an immigration attorney is crucial, just like there's so many nuances in deprivation law. There's so many nuances in immigration law, and it changes every day. It changes, and it could be the difference between simply filling out another form or putting the child at risk to now being deported when he spent his whole life here. And keep your options open. Maybe SIJS isn't going to work for this child, but you may be able to get mom and 3 other kids legal through a U visa or a VAWA petition. There's so many other options out there once you start peeling back and looking at the options. And finally, the very last thing, if a child's in deportation and there's just no relief, there's still one more relief available. It's called voluntary departure. Children under 18 do not accrue illegal presence, which is good, because anyone who's an adult who's been in the United States more than 1 year accrues a 10-year bar. The minute they leave the United States, they're not coming back for 10 years. That doesn't apply to children. So if children have to go back to their homeland, it's better that we get them out before 18 so they don't accrue any illegal presence that would affect them in their future. We're maintaining their rights for the future. So if they want to come back as a student, they want to come back as a visitor, or they want to come back because they have a 21-year-old brother who petitioned for them, in the future that won't be a bar from them ever coming back. And again, selective service. That's like my mantra. Selective service, selective service. We're running out of time, so I'm not going to tell you a whole bunch about my cases because I want to answer questions.
Speak some about the remedies available for children under the DREAM Act. I've heard of it, but I'm not sure.
There is no DREAM Act.
There's no DREAM Act anymore?
Nope. We've been trying to have a DREAM Act for 10 years. We came really close last year to having a DREAM Act, and it's on the floor again. I could tell you all day the many different renditions of what have gone before, but we just don't know what it's going to be.
What is the DREAM Act?
The DREAM Act was proposed for children who were brought here as youngsters and who've gone through school, got good grades, stayed out of trouble, did everything that we expect kids to do, and then found out when they're 18 that they're undocumented. And so hopefully, if the DREAM Act is ever passed, it would be a path to residency for those children. It would not be a path to residency for their parents who brought them here. But if they would to maintain good grades through college, I can't even tell you specifics because we don't know what it might be or not be in its final rendition. But we're hoping that something like that would happen. We don't know. We don't know what it's going to be or not be. Mm-hmm. Something like that. The other thing that I should let you know, kids are being told you're undocumented, you're illegal, so you can't go to college. That's not true. That's not true at all. You can go to any school that will accept you. I imagine in Georgia, a state school is not going to accept you because they're prohibited. But if you go to a private school and you get a scholarship and you want to continue to study, it's not illegal to learn. And there's a lot of Latino scholarships, there's a lot of specifically undocumented scholarships in Georgia to combat that. There's a lot of kids who are getting sports scholarships to private schools. So it's not illegal to learn. For a while, they tried to keep kids out of high school, and I'm just like, why would you want to keep kids uneducated and in the streets?
If both parents were illegals and they brought the child here when the child was, say, 4 years old, and the uncle then applied for his brother before the sunset date for 245I, April 30th of 2000, was it 2001?
2001.
Yeah. Is the child automatically grandfathered in with the parent? With
That's
the
a
father?
complicated question. Her question was, if they came here undocumented, I think that's what you said, and they brought their 2 children who were born in another country, so they too were undocumented. But the father's brother had petitioned for him back when we had amnesty. And everybody says, ooh, amnesty's a bad word. It's not, it worked. It's something we're hoping for the future. So there was a ruling that if you had applied for a benefit, a family petition prior to April 30th of 2001, you could pay a penalty of $1,000 to forgive your unlawful entry. And then you can go through the process, and if you qualify, you can adjust your status. The problem is, you know, there's so many questions that. Is brother a citizen or a resident? Was he a citizen or was he a resident when he applied?
Citizen.
Okay, so he's a citizen, and is it Mexico?
Yes.
Okay. Family petitions for brothers and sisters from Mexico have to be pending about 12 years. That just doesn't seem reasonable, does it? That's our immigration process. It could have been that now, 12 years or more later, 15 years, their number's ripe. And how we know that a number's ripe is that we look at the visa bulletin every month, and that tells us this category, this country, we're processing petitions that were submitted that day. There's petitions that are being processed from the early 80s still. That's how behind we are in the limited amount of petitions we have for family members. If his number's ripe, then I imagine that the child was not included on the petition. Maybe they were. A lot of times they aren't. You can do an amendment, and they will be included. And the good thing is, I believe, and it's been a while since I've looked at it, I think they probably have to pay $1,000 for each of the adults, and the children won't have to pay the penalty. But you can read the 245I regulation actually on the form. If the number's ripe, they can apply, and that's one way that they kind of waited it out. They never got that 10-year bar because they never left. That's another key. They can't have left. Can't have been deported, can't have left. I mean, there's so many other questions to ask. But there's a chance then that that child could go from spending his life here undocumented to becoming a permanent resident.
Okay, well, there's another issue. A child married a U.S. citizen.
Well, then the child's not a child anymore.
Once the child married, then the child's married.
How old's the child?
He's 20.
Okay, so you need to stop saying child at 20. This young man married a citizen. That's a more complicated question than I can answer today. I would have to reread the law. I'm not sure if you can grandfather an I-130 petition that you were just a derivative on. I'd have to read that. I think there may be a way, but I'd have to read it. There's a possibility. There's also the possibility that if he was to divorce, he would go back into being a child before he's 21 and adjustable. Maybe they're having problems. I don't know. So.
Rebecca, why did you say the petition, why did it have to be pending for 12 months? What's the reason?
12 years.
12 years.
It shouldn't have to be pending that long. That's crazy. That's because...
That's a deterrent for them to want
to... Exactly. It's so hard. No. It's so hard. I mean, I wish that fixing our immigration problems were that easy. They're just not. It's complicated. There's an awful lot of people who want to come here, and we have a broken system. I can't fix that, but I can fix children, and I can fix some families. So it's difficult. The best information that you hear today is don't take chances and contact an immigration attorney. Catholic Charities, any other reputable AILA immigration attorney. Atlanta has a very tight network. The majority of them are very good. You can read AVVO reports. Just contact somebody that you trust, and you have my information too, and you're welcome to contact me, and I'd be more than glad to help you. My phone number, that's my cell phone on the first page. Feel free to call me. Don't do it on weekends. I'm not as nice. But I'll be glad to help you with any questions and point you in the right direction. Yeah. All right, that's it. Thank you so much for your attention.